The National Assembly has passed an amendment to the Electoral Act 2022 to recognize statutory delegates at primaries, congresses and conventions of political parties. The recent House of Representatives passage is in concurrence with the Senate, which had earlier held an emergency session to correct what the House called a fundamental error. Well, the National Assembly passed the bill for the act while the President, Muhammadu Buhari, signed it into law. As political parties are close to conducting primaries to elect candidates for the 2023 general elections, the act did not provide for members elected into public offices and executives of the parties, known as statutory delegates, to participate and vote in the conventions, congresses, or meetings of their parties.
The extant subsection only clearly provides for the participation of elected delegates in the conventions, congresses or meetings of political parties held to nominate candidates for political parties. Mr. President, this is an unintended error.
Such an unintended clause has to be amended before the party primaries start in the next 8 days. So this is an emergency effort to ensure that nobody is denied his or rightful opportunity as a delegate, and especially the statutory delegates, and these are those who are elected.
President of the Nigerian Senate there, Ahmed Lawan, and before him was Deputy Senate President Ovie Emeagwege. Well, for more on this, I'm being joined now by Senior Advocate of Nigeria, Kunle Adegoke. He joins us from Lagos. Thank you so much, Senior Advocate, for being on the show today.
Thank you very much. It's my pleasure to be here.
Great. Let me start by asking you, do you think we are reading too much meaning into the amendment of the Electoral Act to allow for statutory delegates as self-preserving and encouraging money bag politics in Nigeria?
I do not think that would be a correct stance to take. Money bag politics will still rule if the society allows it, if the system allows it, whether with or without participation of statutory delegates. And to that extent, whoever or in whatever capacity a delegate is coming to participate in a primary election of a political party, if the process is allowed to be dominated by money politics, definitely those who are money bags will determine the outcome, insofar as the delegates are ready to sell their votes. So whether they are statutory delegates or they are delegates elected specifically for the purposes of the convention or the meeting or congress of a party towards nominating political candidates, definitely money politics will have a role to play insofar as the system allows it.
Then, if it's not for money bags, do you think it was self-preserving for them to have taken this action? Because some would say this is shifting the goalposts while the game is on already. As you know, political parties have released guidelines for their primaries. Some have even gone ahead to start in some states.
But the basic thing is that the legislature has the power to amend the law at any point in time. And we observed this particular error some time ago, that excluding those who are statutory delegates would reduce the number of delegates substantially to the extent that we may have scanty representation in the determination of who would be the candidate of some political parties. To this extent, the state of the law as at today with the amendment has taken care of that issue, which has generated a lot of furore in the past few weeks after the Electoral Act was passed into law. To this extent, I believe that political parties are fundamentally required to comply with the provisions of the statutes. Their constitution or guidelines for nominating candidates or carrying out a process is a subsidiary legislation which ought to follow the position of the Electoral Act or the enabling law, as the case may be. So in this instance, it is desirable for political parties to tailor, which is in line with a piece of advice that I rendered recently to the effect that political parties will have to follow what the Electoral Act has stipulated. If there have been efforts on the part of some political parties wanting to amend their constitution or guidelines to fall in line with the erstwhile position of the Electoral Act, they have been saved such efforts and expenses. But for those who have not actually done it, the agitation actually even came from political parties who saw the lacuna and pointed it out. And in this particular instance, the executive together with the legislature have a reason to ensure that the law is brought to recognize the statutory delegates to be able to participate in this process.
Advocates, I know you mentioned that the lawmakers, the legislature is at liberty to make laws at any time. But what about the speed of this amendment? Should we also be bothered about that? Some have described it as unprecedented. And what does it say about our National Assembly and their ability to make laws in timely fashion?
Yes, in fact, the current National Assembly has passed quite a number of laws in a very speedy manner. The fundamental is not the length of time it takes to actually pass a particular law, carry out an amendment. The most important is the depth of reasoning that actually goes into such a process. If the reasoning on which the amendment is premised is sound, the outcome of the amendment process will equally be sound. But where the premise is faulty, the unfortunate consequence will be that the law itself will be placed on a very shaky foundation. And the implication is that in the next few days, in the next few weeks, people will see the lacuna again manifesting that will agitate the polity and will compel another process of agitation, another process of rumination and deliberation on whether the law is actually solving any problem. It is unwise where there isn't a problem for the legislature to embark on an amendment process or to embark on a legislative process to provide a solution to a non-existing problem, except where such a process is premised on a foresight that has predicted the possibility, the emergence in future of a problem that they are trying to tackle ahead. That would be wise and very sound for a legislature to actually do. And this is why the speed with which the amendment is carried out, if we all agree that there is a lacuna, there is a fault in the reasoning process that made it impossible for statutory delegates to participate in the electoral process that is coming on in terms of the primaries of political parties, then it becomes very expedient, it becomes very important for the legislature to amend the Electoral Act so as to be able to take care of this agitation from the people, from the political parties themselves.
Okay, so we understand time is of the essence for them. And let's talk about the Electoral Act, but another section of it. The one that was in court, the controversial 8412. Today, the Court of Appeal here in Abuja set aside the Umahia judgment, which voided that section. The court says the provision is unconstitutional. I wonder if you agree with the judgment. It also said that it denies a class of Nigerian citizens the right to participate in elections. Do you agree with this judgment?
Well, what I've read about the judgment is just a summary produced through the social media. I've not been able to access the comprehensive judgment itself. However, what I understand the Court of Appeal said is to the effect that the decision of the Umuahia Federal High Court will not be correct to the extent that the person that challenged the plaintiff that brought the action had no local standing to actually bring the action in the first place. And when you look at the position of our law, it requires a plaintiff to have sufficient, what we call sufficient interest in the subject matter of litigation for him to be able to access the court. Where there isn't such sufficient interest that can place the person on a good footing to challenge, to bring the challenge, to express a grievance, definitely the person is just a meddlesome interloper, will be a busybody that is concerning himself with an issue that ought not to be his problem. But in a situation where the court has made such a pronouncement that the person who brought the action itself is a busybody, then the implication is that there is no basis for the action in the first place. However, from my perspective, I do not think it will be right for the court to say that Section 84.12 is not unconstitutional. A clear look at Section 84.12 will show that it is premised on an unconstitutional pedestal. And the reasoning for this is that if you look at Section 84.12, it is stipulating that a political appointee shall not be eligible to participate in the primary election of a party, either to vote or be voted for. Let us dissect it. If the provision has said that a political appointee cannot participate in the primary election of a party to vote, that means that it cannot be a delegate. That one may, to a large extent, be correct. But for it to say that it cannot be voted for, that means that it cannot even contest an election while holding the office of a political appointee. That would be unconstitutional. The reason is this. If you look at the Constitution, is an embodiment of determination of who actually is qualified to contest an election, or what are the conditions that a person must meet to contest certain elections mentioned in the Constitution itself. So from the presidency to the vice president position, to the Senate, to the House of Reps and State House of Assembly, you see that the provisions are quite similar from Section 66 to Section 107, and then what, like that. The provisions are similar. The only disqualification for a person mentioned by the Constitution that will be a ground for disqualification if a person is holding an office is where such a person is employed in the public service of the federation or public service of the state. So the Constitution has specifically stated that anybody who is employed in the public service of the federation or of a state is not qualified to contest an election. The Constitution does not say a political appointee shall not be qualified to contest an election. And where the Section 84.12 is saying that a political appointee cannot even be nominated in the first place, that means that he is not qualified to contest the general election when he is a political appointee. That provision is not contained in the Constitution. It's an innovation, it's an introduction by the Electoral Act. And that will be inconsistent. What the Constitution has permitted, the Electoral Act is denying. That will be inconsistent with the Constitution. And by Section 1.3 of the Constitution, any provision of an act or law or any law that is inconsistent with the Constitution shall be, to the extent of its inconsistency, be void. So to that extent is my position that the provision of the Electoral Act disqualifying political appointee from being nominated as while holding such an office is inconsistent with the Constitution. I want to hear what the Supreme Court is going to say on this provision, but I believe that from what I've read from the decision of the Court of Appeal handed down this morning is to the extent that if the person who brought the action has no local standing to challenge, to bring the action in the first place, then the case is bad on its own merit, that extent.
All right, senior advocates, let us agree without conceding for the purpose of this conversation to your point and make a case. What about political parties that are pegging their nomination forms at 100 million naira, which is a whopping sum, or 40 million naira in the opposition People's Democratic Party? Does this not amount to discriminating a certain section of Nigerians who are poor and cannot afford it and are members of those political parties? Isn't that double standard? What do you say in that instance? Where do the political parties draw the powers from to discriminate against their own members when it comes to purchasing forms?
Yes, well, with respect to the issue of discrimination, let me treat it this way. In the first place, there must be a stipulation. There will be monetary stipulation for purchasing an expression of interest form and nomination form. The challenge here is the amount that is actually involved. And to the extent that maybe a person is not able to afford, even if a nomination form is being sold for 100 naira, there might be some classes of Nigerians who might not be able to afford such an amount. We cannot say that to that extent it is discrimination against them. However, where nomination forms of political parties are priced beyond the reasonable income of a civil servant, to a large extent, I think this is not fair. It is imposing on the polity a corrupt tendency, which may only make those who have access to illicit funds to be able to participate in the process. I am a chieftain, I'm a leader of All Progressives Congress, and I'm bold to say it out. While this position of mine is not consistent with that of my party, I will say, well, my party to that extent may consider it as an internal affair of the party. And the law, to a large extent, considers it an internal affair of the party. What amount is imposed, what amount a form is being sold, it is only for those who can actually afford it. Anybody who is not satisfied with the amount the APC is selling its form has the opportunity to go to NRC or SDP or Action Group, if those political parties are still in existence anyway, to buy their own forms, which may be cheaper. The fundamental is to participate in the electoral process. That who says that may even be a factor that will sway the electorate to say these ones that are not charging exorbitant fees are likely more ready to serve. But our polity is not thinking that way. To the extent that I cannot afford to pay 100 million naira or even 50 million naira to buy a governorship form, I believe that it is exorbitant and it may encourage corrupt practices in the polity.
I see what you did there. It's exorbitant, but it's not discriminatory. Let me just put it out there that what is reasonable as, minimum wage in Nigeria, according to the law, is 30,000 naira. And a lot of state governments are not even able to pay that. But I want to also ask you for a clarification, because this has also been in the public domain. Who is a political appointee and a public servant? I know you touched on it a bit. So with this judgment and this point of yours, can we then say that political appointees and public servants are the same and they should enjoy public servant rule?
No, political appointees are not in the class of persons employed in the public service of the federation or of the states. When we talk about people in the public service of the federation or of the states, there are two classes. First is the class of civil servants. When we talk about civil servants, those employed in the ministries, in the various parastatals of government and what have you, they fall into this category, whereby they can be referred to as civil servants. And they are persons employed in the public service of the federation. Another arm of public service of the federation is the military or the paramilitary. The military, as we all know, are the soldiers, the Air Force men, the naval officers and what have you, and the police, the SSS and what have you. These are people in the military and paramilitary organizations. And to that extent, they are all employed in the public service of the federation, whether civil or military or paramilitary as the case may be. On the other hand, are those who are referred to as political appointees. Who are these? When you look at the Constitution, it establishes the offices of ministers, special advisors, the Attorney General, the Auditor General, and some other offices like that. These offices are occupied by persons appointed by elected officers, elected members of government. For instance, the governor is the one that has the power to appoint commissioners, appoint special advisors, appoint the Attorney General of the state. These are political appointees, and you can trace it down to the level of even the government commissions and what have you, when persons are appointed as maybe members and chairmen of commissions and what do you call it? To this extent, all these people constitute the executive, and as the executive, as members of the executive, they are treated under a separate chapter of the Constitution referred to as Chapter 6 of the Constitution. Part 1 deals with the federal executive, Part 2 deals with the state executive. And when you look at these provisions, you see that specifically it mentioned this political. Commissioners are not elected. Ministers are not elected. So they are political appointees. These are the persons referred to as political appointees who cannot participate in the, according to Section 84.12, who cannot participate in the Congress of a party for nomination of party candidates. So they are different from persons employed. You see that persons employed in the public service of the Federation, they can serve up till 35 years. They are governed by the civil service rules, which give them the lifespan of 60 years of age before they can retire, or 35 years in service before they can retire. A minister cannot serve for 35 years before he's booted out. He has maybe 4-8 years at the pleasure. It's at the pleasure of the appointer, whether president or governor, as the case may be. So these persons, the Supreme Court has stated they are not persons employed in the public service of the Federation. Those who are in the public service of the Federation are the ones that the Constitution has said must resign 30 days, minimum of 30 days to the election in which they want to participate in.
Okay, thank you for that clarification. And that brings me to my question, because about an hour or two ago, President Muhammadu Buhari directed that all members of his Federal Executive Council should, on or before Monday, the 16th of May, resign, those who are seeking political elective offices. But there's that argument, and who are these people? Who are these people the president refers to as members of Federal Executive Council meeting? Does it affect, for instance, the vice president? And of course, that clarification was made that the vice president is an elected official. Does it affect someone like the governor of the Central Bank of Nigeria, who has not said he's contesting, but groups have bought him forms, and there's still that debate that is hanging. But can you make sense of what's going on between the executive and the judiciary here? President Muhammadu Buhari says, go and resign to go and seek your offices. But in the courts today, we saw the Court of Appeal saying they can stay on to seek these offices. What do you make of this debate?
Yes, I think the president in this situation is trying to protect the interest of the party. The political parties are trying to comply with Section 84.12 of the Constitution.
We focused on the completion
of
major road and rail
Right. I can see the president is talking, so in deference to him, I have to keep quiet.
Live visual. But you can go ahead, sir. That was moments ago.
Right.
Yes,
so
sir.
now the point is, the persons that the president is talking about are actually the ministers, the persons he appointed into various political offices. The vice president was elected and cannot be made to resign. Just like the president, were he to have an opportunity of contesting again, will not have to resign before he can participate in the process. When you look at what the president is doing, what the president has directed is to safeguard the interest of the party, APC. And politicians are being careful now. Political parties are being careful on the basis that they don't know what the final court, the Supreme Court, the highest court of the land, is going to say on this provision, where a minister sits in office, contests a particular elective office, and he wins the election, only for the Supreme Court to uphold the validity of Section 84.12 and say, look, anybody who was a political appointee who participated in the process, the whole thing he did is a nullity and what have you. The party that featured such a candidate might lose that office. And our experience in Zamfara, in which our Congress was nullified, our experience in places like Rivers, in many other states like that, this experience has really taught us a lesson that we should be careful. So it might be better to tell such political appointees to rather resign their offices so that the party will not risk losing such seats. But I am convinced, if I were to be Mr. President, with my conviction of the correct interpretation of Section 84.12 that it is unconstitutional, I would rather challenge it up to the Supreme Court. This is an issue that can be determined by the Supreme Court in 2-3 days. Yes, it has been done before. In a matter of 2-3 days, the Supreme Court pronounced on certain emergency situations calling for a judicial interpretation. In such a situation, the court will waive the rules of court, requiring a party to file brief of argument and what have you. In such a situation, we go to court as lawyers to make submissions and make a summary of it. The other party too will make his own submission, and the Supreme Court will rule probably the following day. It has been done before. I think there was a case during the time of during the days of Esho, and I even of recent, when cases like that were pursued up to the Supreme Court, and the court treated it with urgency and decided the position of the law. So in this instance, anybody, I think what the federal government should rather do is to approach the Supreme Court right now for the interpretation, more so that the Court of Appeal has pronounced today. I can bet you by early next week, the Supreme Court will make a pronouncement on it. Worst case scenario, Supreme Court will call for emergency session, and some notable lawyers will be invited to come and make submissions as friends of the court. So in a matter of 2-3 days, the court will determine the issue.
Well, I guess the president was trying to err on the side of caution, like you've said, and of course the APC as well. But that's a good place to leave this conversation. I really do appreciate your time on the show today. Senior Advocate of Nigeria, Kunle Adegoke, for sparing us your time. Thank you.